simple, effective, quick, accessible, smoother. The object of the code is not to take revenge against the defendant, against the other side. No, it is not penal. It is just to facilitate the justice. For doing justice, what can be do is to be done, and not to punish, and even not to trap, not to create hurdle, not to create hardship on the part of the whosoever being a stakeholder. Not only at the time. Procedural right. Therefore, while interpreting the procedural law, necessary every focus of the judge should be by any means substantive law shall not, and right created by substantive law shall not be overridden by the procedural interpretation. What I mean to say. Uh, the Code of Civil Procedure 1908 is commenced on 1st January 1909. Um, the code is applicable throughout India except the state of Nagaland and some tribal areas. The state of Nagaland is empowered under the code to notify in the official gazette and declare that the provision of the Code of Civil Procedure, the state is going to extend to the state of Nagaland. So there is a council at the Nagaland who investigate and inquire the things, because in the Nagaland the custom and tradition prevails over the legislative laws or laws of the parliament. The administration of justice in the Nagaland is taken place in accordance with their own custom of the so-called tribals, and therefore under constitution the sixth schedule Constitution as well as Article 371A is specially mentioned and empower the state to extend the provisions. The sixth schedule is for the tribal areas. Their custom and traditions needs to be conserved. So Nagaland was the part of Assam before 1972. And keeping in mind the peculiarity of the so-called situation, the extension of the Code of Civil Procedure is handed over to the state of Nagaland. So far as the scope is concerned, the code particularly states that nothing in this said code should be interpreted as limiting or otherwise affecting the court's inherent jurisdiction. Inherent jurisdiction is prescribed under section 151 of the code. This provision is used by the court when the court realized that for doing the justice, other than this provision, not recourse,ing the purpose for which it is made, the provisions are helpless in doing the justice to the court, then court can exercise the power under section 151. This is called as inherent power, and this power is given similar to the equitable jurisdiction. The court has equitable exercise for doing the complete justice, for doing the justice to the litigant. The court can exercise this extraordinary power and pronounce the judgment and pass the decree. So nothing in this section should be interpreted as limiting or otherwise affecting the court's inherent authority to issue